Assembly 7575A, calendar number 503, Mr. Lancman, an act to amend the penal law.
An explanation is requested. Mr. Lancman.
Yes, I'd be happy to. This legislation addresses some shocking facts. That is that more than a third of the women murdered in the United States are murdered with a gun at the hands of their male domestic partner, and that access to firearms yields a more than five-fold increase in the risk of domestic partner homicide when considering other factors of abuse. It expands the category of serious offenses committed against a family or household member, which would make one ineligible to obtain a firearms license and prohibit one from possessing or purchasing a rifle, shotgun, or pistol.
Mr. Jordan.
Thank you, Mr. Speaker. Will the sponsor yield?
Mr. Lancman.
Yes, I'd be happy to.
Included in the expanse of definition of a serious offense, does this include only crimes, or does it include violations as well?
I believe it includes two violations. The crimes that are include disorderly conduct, harassment in the first and second degree, aggravated harassment, stalking, criminal mischief, menacing, reckless endangerment, assault, and attempted assault. And of those crimes, disorderly conduct and harassment in the second degree are violations.
And are these offenses only those that are subject to prosecution in criminal court, or would it also include offenses being prosecuted in family court?
I believe that these would be also offenses that are prosecuted in family court.
Do you know what the standard of proof is for family offenses brought in family court as compared to criminal court?
I believe the offense, the standard in family court is the same as it would be in a civil proceeding, preponderance of the evidence.
And actually, I believe in criminal court it's beyond a reasonable doubt.
No, I said in family court it would be the same as in a civil proceeding.
Oh, in civil proceeding. Oh, I'm sorry.
That's okay.
It's a little noisy behind me, and I couldn't hear the reference to civil. In family court, unlike criminal court, we will often prosecute matters of family offense against individuals under 18, actually under 16. Is that correct?
I believe so.
And if a 14 or 15 or 12-year-old is found guilty of a family offense under this definition, will that record be expunged when they turn 18?
I don't know the answer to that question. I'm advised that it can be under a juvenile offender application to the court.
So that unlike convictions of an offense that would otherwise constitute a crime, which do not go on their record, I believe you're correct that a conviction or an adjudication, we don't even use criminal terms, an adjudication of a disorderly conduct, where it could be two brothers get in an argument at school, and to dispose of it, they dispose of it by pleading to a disorderly conduct type charge. That would be on their record permanently. And under this bill, for that offense adjudicated in family court, they would be banned from ever hunting or otherwise possessing a rifle or, and also a pistol, which would require a permit. Is that a fair summary of the progression that could occur?
I think that it is, although, of course, they could, again, make an application to the court, I guess, when they turn 18.
To go further, if somebody, regardless of the circumstances, is protesting, involved in a public protest, and the police arrive and say, disperse, you don't have a valid license, or they simply say disperse, and a person refuses to, and they are charged and plead to a disorderly conduct charge, and they had their child with them, and it was brought in family court because they had the child with them, would that constitute a family offense under this bill?
Good. I would think that it would not, because as the bill's written, the victim of the crime needs to be a family or household member. And I'm not sure that in the facts as you laid them out, that the child who was with the parent who was, pled to a disorderly conduct violation would be considered the victim.
And I think I missed part of the factual scenario. The reason they were charged is because they had the child with them. That would bootstrap this into a family offense, would it not?
I don't think so, because again, the bill says where the victim of such offense was a family or household member, and I don't believe in that scenario that the child would be a victim of the disorderly conduct.
I think my focus here is, and Mr. Speaker, on the bill, and I appreciate your
Mr.
indulgence.
Lancman to explain his vote.
Thank you, Mr. Speaker. I appreciate the questions that were asked of me, and I am certainly sensitive to the fact that the criminal laws that we pass should be considered carefully and with an understanding of the rights of our fellow New Yorkers that they implicate. However, I would urge my colleagues, and I consider this myself in voting in favor of this legislation, not to be distracted by the remote potential consequences of a piece of legislation that we support that, in the vast majority of situations, provides important protection to our fellow New Yorkers and will be a very, very important tool in defeating the scourge of domestic violence. We have judges and a judicial system that is more than capable of weeding out the extremely remote possibility of cases where the application of a particular law would be inappropriate. But here we are addressing a specific problem of primarily women being subject to terrible violence at the hand of their partners, and voting in favor of this legislation because I believe it strikes a reasonable balance between the rights of gun owners and the need to protect people from domestic violence. I will be voting in the affirmative.
Mr. Lancman in the affirmative. Are there any other votes? Announce the results.
Ayes 78, noes 49.
The bill is passed.